This is part 10 of the video series, Handling Your Car Accident Case Without a Lawyer, Without Going to Court. And in this section, we're going to be talking about after you've negotiated a settlement. So the prior section was when settlements stall out. This section is after you've actually negotiated a settlement. What we're going to be talking about is the release, which is the agreement between you and the other side to drop the claim, reimbursing medical insurance, what to do if you have liens, statutory liens, ERISA, Medicare and MediCal, method for reimbursement, negotiation. Now, I mentioned earlier in the videos that I'm not giving legal advice. This is just a general legal guide. By watching these videos, you don't become a client. I'm going to be talking about law as it applies to California in 2020, and it changes from state to state and from time to time. Who am I? I'm Jonathan Howell. I'm an attorney in Los Angeles, practice throughout California, have a lot of experience dealing with insurance companies and negotiating on injury claims. When you finish negotiating the case, when you finally agreed to a number to settle the case, typically the insurance company will send you something called the release. The release is a document, it's like a contract that you're going to sign, and basically says that in exchange for the money that you negotiated, you are going to drop your claim against that person, the defendant, whoever hurt you. And when you read it, it's important you read it very carefully, and you can get tripped up on these, and it's always a good idea to have a lawyer look them over if you can. But you got to you want to make sure that the amount is right. You want to make sure that the people you're releasing is correct. You don't want to be releasing people you didn't know about, or if there was an employer or other things, you need to know about that. And you need to make sure that the terms of the release are okay, because sometimes I've seen them put things in there that are inappropriate, can create liability for you down the line. The consequence of signing the document means that once you sign it, typically the way they write these, you cannot come back and ask for more money. That's it. So if you're hurt further down the line, if you have some ongoing symptoms, they get worse. If after you sign this and you find out that you're now a surgical candidate, you cannot go back and sue the person. You're stuck. And that's why it's really important that you pay close attention to this document, the release, and probably have an attorney review it if you can. Read the document. It's going to have a lot of, I've seen all sorts of different releases, from 1-page releases to releases that are 10 pages that have all sorts of terms. And even for a lawyer, some of the releases can get very complicated. Read it, and if you don't understand it, ask a lawyer to help you with it. Again, though, the most important things are to make sure the numbers are correct, the amount, and who you're releasing, the dates, and some of the core information. While you were handling the case, you may have incurred some liens. So, for example, if you got emergency room treatment, there's a special statutory lien, which basically means that the ER can recover from your settlement, and it's built right into the code. And you have to protect them and pay them back if they follow certain rules, like sending you notice about it. You got to be careful about that, because if you take the money and you don't protect them and pay those liens, you can get sued. You can also enter lien agreements with doctors. So typically attorneys do that, but if you go to see a chiropractor, for example, and they say, you know what, just sign this agreement when you get the money. I can't imagine that they would do that with an individual, but they might. Typically that they collect through MedPay, but you need to protect those, and that's what lawyers do all the time. ERISA is a type of health insurance. They don't necessarily have a lien, but they have a right to reimbursement, and we'll be talking about that in general also, but you need to watch out for that and pay back these insurance companies. The insurance companies, they have a right to reimbursement if you recover money, and they have third-party companies that just seems like they just scour medical records or put on notice when they hear about an injury, and ERISA does that also. If you don't pay them, you could potentially be liable for the reimbursement. In ERISA cases, I've heard of them withholding medical treatment down the line until you've incurred enough medical treatment that would reimburse them for the amount you should have paid them. Medicare and MediCal. Medicare is the federal program for providing health insurance, typically to people over 65, but there's some other people who qualify for that. You have to reimburse them for treatment that they paid for, and it's in the agreement that they have. And in fact, they've written the law in such a way that if you don't protect that, they can sue you. They can sue the insurance company. So the insurance companies also get panicked about that. And if there's any chance that you have Medicare, they will typically require you to reach out to them and get some Medicare amounts. MediCal is California's health insurance, typically for people who make under a certain amount or have disabilities along those lines. Same thing. You've got to protect them. You've got to notify MediCal and reimburse them for money that they paid. It's a big pain in the butt. Sometimes it can take a long time and can slow the settlement down. The insurance company, like I said, wants to protect those Medicare and MediCal because they know that if they don't, they can get in trouble and in fact sued by the state or the government. And oftentimes they'll want to issue a separate check directly to MediCal, or Medicare. So you got to kind of be aware of that. You want to negotiate with them up front to get some final number before the check gets issued, because you can usually negotiate with them. When you're negotiating the reimbursement for whatever it is, health insurance, for MediCal, Medicare, ERISA, you want to give them the amount of bills that you've incurred. You want to know the total amount of settlement. You want to know the total extent of your injuries, because you're going to be explaining why maybe, for example, the insurance was limited. The policy limits was $15,000, but the bills were $20,000, and they're going to have to all take a haircut on that because of the amount of insurance available. Also, it's important to talk about the extent of injuries, because if you had a serious debilitating injury and the settlement does not make you whole, which is a legal term, basically it's not a fair settlement under the circumstances, but you had to take it because of the amount of insurance available, for example, you can argue that they should take less because you weren't made whole. When an attorney is involved, they can also argue that the amount for reimbursement should be reduced to include the amount of attorney's fees, because the attorney had to work in order to get the reimbursement, but for the attorney's work, they wouldn't get reimbursed. So that's what you need to be aware of when you're negotiating and finalizing the settlement. There's some other stuff out there. This is a general guide of things to be aware of. If you have any questions or want further information, please visit my website, howelljust.com, and book a consultation.